Thank you. Good afternoon, everybody. My name is Tim Sheehan. I'm a partner in Foley and Lardner LLP's Milwaukee office. I'm co-chair of our international business team and a member of our food and beverage industry team. And I want to welcome you all to the second installment of Foley and Lardner's continuing webinar series called NewsFeed. As the host mentioned, our topic today is food packaging and country of origin marking and improving compliance in that respect. We're going to touch a number of issues today. My practice involves trade regulation, including matters arising under the U.S. customs laws and regulations. Joining me on the panel today are Lisa Noller, a litigating partner in our Chicago office. Lisa is a former U.S. assistant attorney and is a member of the firm's government enforcement, compliance, and white-collar defense practice group, and a member of the food and beverage industry team. She's an experienced trial lawyer, having more than 15 years of investigating and trying complex civil and, of interest to everybody here, criminal cases, and is very active in that regard. Rich Casper is a partner in the Milwaukee office of Foley and Lardner and is the dean of contractual lawyers within the firm. He has practiced for many years in the area of commercial transactions and business counseling. His clients include manufacturers and vendors of a variety of goods and services, including food and food ingredients. I'm happy that you could all join us here today. A couple of housekeeping items to take care of. Today's program will run for 1 hour. We will apply for 1 general CLE credit for today's program. All New York and New Jersey attendees applying for CLE credit must fill out an attorney affirmation form and write down the course code that will be given during today's web conference. A form and today's slides can be obtained in the materials section on your screen. And please, questions can be submitted throughout the presentations through the Q&A box. Our topic today is very timely. One reads regularly news stories of adulterated food ingredients being manufactured in China and other emerging countries. One reads of food products being transshipped or mislabeled to avoid anti-dumping duties and countervailing duties. And one reads of ongoing concerns about food products that are mislabeled or improperly packaged or marked. This is a global problem. Horse meat and Swedish meatballs, a variety of other products containing contamination being shipped out of China. All these raise concerns in the minds of U.S. consumers and confirm the need for vigorous laws and regulations designed to let consumers know where their food products come from. This need is addressed in U.S. law under U.S. customs regulations. And today we're going to talk about that and some other issues. We're going to talk about customs requirements with respect to country of origin in food packaging. We'll touch briefly on USDA AMS requirements. We'll talk about the possibility of marking your products as made in USA. And then we'll talk about who's responsible for making sure that the food industry gets it right. We'll talk about penalties and enforcement efforts ongoing by the federal government. And we'll talk a little bit about steps one can take to improve supply chain integrity by improving your compliant posture. So, customs, first line of defense. Ever since Customs and Border Protection agents were given guns following the disaster of 9/11, they seem to have stepped up their efforts to be aggressive protectors of U.S. borders, not only against terrorism, but against the entry of counterfeit products, mislabeled and tainted products as well. Ever since the original Tariff Act was passed in the 1930s, it has provided that every product entering the U.S. customs territory must be appropriately marked to show the U.S. or to show the country of origin. The marking requirements are apparently straightforward. They need to be marked with the country of origin in a conspicuous place, in a legible fashion, and in a way that is as indelible and permanent as the nature of the product or the container will allow. And the goal of all this is to inform the ultimate purchaser of the product where the product came from, the country of origin. Customs regulations provide special rules for bulk goods and for special commodities, the so-called J list of products. Now, natural food products are on the J list. And for products on the J list, only the outer container, if there is one, for the product, at least the outer container that will be presented to the consumer, needs to be marked. For example, grapes from Chile, grapes are generally sold in those thin plastic cones. If that's the package that's shown to a consumer, then the grapes, when they enter the U.S., need to have those plastic sleeves marked with the country of origin. Mangoes that are sold 6 to a carton, imported from India, well, the carton needs to disclose that the mangoes in that carton were a product of India. The rules with respect to the import of natural products can be quite complicated because natural products, as imported, are oftentimes repackaged or processed into other products. An importer has an affirmative obligation to instruct the buyer of any product that is liable or prone to be repackaged, that a buyer that repackages the product must mark the repackaged product with the proper country of origin. The port through which the imported products enter can require the importer to deliver a certification that it will inform any buyers of the goods that the repackaged product must show the country of origin. Going down the supply chain, the buyer of those imported goods must, if he repackages them or processes them without a substantial transformation, mark the country of origin on the repackaged or processed product, and at the request of customs needs to deliver a certificate confirming that the repackaged goods have been properly marked. Now, a lot of legal issues surround the question of whether or not a product has merely been repackaged or whether it has been reprocessed into a new and different article, a substantial transformation. A brief word on country of origin. The U.S. is a party to 14 different free trade agreements. Those free trade agreements set forth rules of origin to determine whether an imported product is entitled to a tariff preference for goods, say, from Korea or from Canada or from Mexico. The marking rules, the determination of marking requirements for such free trade agreement products are different from the rules of origin for determining trade preference. So you need to be careful. As to the downstream buyer of the imported product, it really doesn't matter. The sole question of whether it's been sufficiently processed to constitute a new article, and that will determine how the processed or repackaged product needs to be marked. But the goal is to disclose the country of origin to the ultimate purchaser. Ultimate purchaser is defined in the regulations as generally the last person in the United States who will receive the article in the form in which it is imported. So if we're looking at U.S. purchasers of imported natural food products that are going to be processed or repackaged, that company needs to determine whether the its manipulation of the imported product or its processing of it rises to a point at which the product is deemed to have been substantially transformed. If a processor or repackager in the U.S. simply blends or dilutes or evaporates the imported product without changing its essence, without creating a new and different product, then the processor is not the ultimate purchaser, and the processor therefore has the continuing obligation to mark its product with the country of origin of its ingredients. Now, this oftentimes comes up in the packaging of fluid items that can be made up entirely or partially of imported stuff. So you have imported olive oil. You can buy olive oil from Italy. You buy olive oil from Spain. But if you blend the two into a single bottle of olive oil, that label has to show olive oil from Italy and Spain. Scotch whiskeys. If you have a blended whiskey and it has got some U.S. whiskey blended in to make a blended Scotch whiskey, question whether you can call it Scotch, but in any event, you need to disclose the origin of the ingredients of that blended product. If a product is more substantially reworked, so processed or changed that it undergoes a substantial transformation into a new and different article, then the processor doesn't have an obligation under the customs marking requirements to disclose the country of origin of the imported ingredients. For example, if you've got, the determination of whether there's been a substantial transformation can be quite complicated. If you are packing imported crab meat, if you're importing crabs and your facility picks the crab meat out of the shells, processes it and cans it, if you're importing crab from Taiwan, say, the lump crab meat in the can still has to be marked product of Taiwan. If you import peanut slurry from Canada and you're going to make it into peanut butter in the U.S., well, making peanut butter from raw peanuts, well, that is a substantial transformation. Making peanut butter from imported peanut slurry from Canada, well, that is not a substantial transformation. If you import fish fillets from, say, Vietnam, and your facility seasons them, breads them, and packages them for sale as fried fish fillets, that is a substantial transformation, oddly enough. The rules have a rhyme and reason that is sometimes difficult to track and difficult to follow. There are a lot of published rulings out there by the Customs Service designed to attempt to give you some guidance on what is or is not a substantial transformation. But it's incumbent on the processor to have a good handle on the extent of its processing and how the Customs Service would view that as being or not being a substantial transformation of the imported products. We're going to nod briefly in the direction of other agencies. Not only Customs has a role in determining how processed foods need to be marked with respect to country of origin. Other agencies put their oar in. It's not an FDA issue as such, although the FDA does impose obligations not to make false statements regarding geographic origin, or generally they prohibit false or misleading labeling of foods, and those would apply in this circumstance. The FDA tends to defer to Customs in terms of what's the appropriate country of origin labeling. So you're at a low risk of inconsistent treatment, at least under these rules. The U.S. Department of Agriculture, the Agricultural Marketing Service, has its own requirements that it can apply to particular products. You've got the country of origin labeling, the cool requirements that were imposed in the 90s, at the end of the 90s. We won't spend a lot of time on that. It applies to any product that is processed, any product that is entered as a raw product. If the product is processed in accordance with the USDA regulations, it's exempt. Well, a product may be processed under the USDA rules and therefore exempt from the country of origin marking requirement, but it won't undergo a substantial transformation under the customs regulations. So, for example, if your company is importing peas from Canada and carrots from Mexico, or frozen peas from Canada, frozen peas from Mexico, and you mix them together and package them as frozen peas and carrots, well, under the cool rules, that is treated as having been sufficiently processed to be exempt from the country of origin labeling requirements by the USDA. However, since neither the peas nor the carrots have undergone a substantial transformation, they've simply been mixed together, you still have to disclose on your packaging for customs purposes the country of origin of the peas and the carrots. So you have to disclose peas, product of Canada, carrots, products of Mexico. And then there are special rules applicable to some products. The USDA has special rules dealing with country of origin marking for honey that carries a USDA mark or statement. That's required to be marked with the country of origin. And if you mismark your honey, in addition to penalties like civil fines, you're at risk of losing or being debarred from USDA inspection and certification services. That can be devastating to your food company's ability to continue to do business. Excuse me. Now, we've talked about the affirmative marking obligations imposed by customs or USDA, but some companies see the inherent value in marketing their product as made in the good old USA. And there are some proscriptive, or I should say, prohibitions involved in how and when you might claim that your product is made in the USA, and Rich Casper will explore that topic with you.
Okay, thanks, Tim. Also in the 1930s, the U.S. adopted the rather vague Federal Trade Commission Act standard that empowered the Federal Trade Commission to prevent unfair and deceptive practices in commerce, a very broad and vague term, one that's been defined over those years since the FTC was created by various focuses that the FTC has adopted over time. And one of the most long-standing and emphatic concerns that the FTC has had concerns claims that products are of U.S. origin. They take the position that a great many consumers care whether products are made in the U.S. or somewhere else, and that they want to patronize companies that make their products in the U.S. So the FTC has for a great many years had a very rigorous set of guidelines for U.S. origin claims that apply both to advertising products and to claims made on packaging. And this applies to food products just like any other product. The FTC guides, which, saying guides makes it sound as though they are not mandatory, and technically that is true. However, these particular guides have been in place for so long and have been so well defined for so long that they might as well be rules that are mandatory. And the FTC certainly treats violations of their guidelines as situations that they have to pursue by enforcement mechanisms. The FTC guides analyze U.S. origin claims by reference to two categories. One is unqualified U.S. origin claims, and the other is qualified. And the FTC standard, if you are making an unqualified claim, is extremely demanding. If you are going to make a claim that your product is made in the U.S. without any qualification, then all or virtually all of the U.S. Content of the product has to be U.S. content. And final assembly, a concept that doesn't apply very well in the food industry, has to be also something that occurs in the U.S. California has their own regulation on the subject, and it appears that their standard is still more demanding than that. They essentially eliminate the virtually all possibility and require that all of the product content has to be U.S. origin in order to say that it is a U.S. product. And California litigators have, for several years, been pretty active in pursuing private causes of action based on the California standard. The FTC standard, the guidelines, are enforceable only by the FTC. There is no private cause of action, although advertisers very frequently make claims against their competitors in proceedings before the NAD division of the Better Business Bureau, where they think that the FTC guidelines are not being followed. Depending on the remoteness of raw materials to the final product that contains a U.S. Origin claim, the content may include something that would be considered a raw material. And in general, with respect to food ingredients, I would have to say that one should expect that all ingredients are going to be insufficiently remote to be disregarded in making a U.S. origin claim. So if you have a product that has any significant foreign content in it, you're going to have to consider that you cannot make an unqualified made in the U.S. claim for that product. The food seller that makes a U.S. origin claim is responsible for making a reasonable inquiry from its suppliers about the origin of the ingredients that it's using, or if a product has been somewhat processed, where the processing occurs. It's not enough just to specify or to ask for the answer to the question, was this product made in the U.S.? Some more inquiry has to be made of a supplier in order to be able to rely on that sort of a statement in making your own unqualified claim. And an unqualified claim is just what it sounds like. It's a claim that either explicitly or implicitly refers to the U.S. As an apparent source of the product, without explaining that the supplier means something less comprehensive than meeting the virtually all standard that we've already referred to. An example of an implicit claim, the most popular example and the most commonly used implicit U.S. origin claim would be the use of the U.S. flag. But it doesn't have to be a flag, a red, white, and blue motif, perhaps even the Statue of Liberty. Without a further explanation means that you are claiming that your product is made in the U.S. and thus all or virtually all the content is U.S. In order to qualify a U.S. origin claim, whether it's explicit made in the USA or implicit the U.S. flag, the qualification has to be clear, it has to be prominent, and it has to be proximate to the claim that's made. So, for example, if you have a package of, let's use Tim's example, peas, that has the American flag on the front of the package, and then on the back of the package you have a small print or even a large print statement that the peas were grown in the U.S. and packaged in Mexico, that is not going to be an appropriate qualification. The qualification would have to be proximate to the placement of the U.S. flag and would have to be prominent. So again, even if you put it right under the U.S. flag, if it was in really small print and the size of the flag was easily noticeable when you first look at the package, that would not be an effective qualification of the claim. Qualification can be a reference to a specific process, such as bottled in the USA or baked in the USA. But if you use the words that are considered general claims, produced, made, processed, some other claim like that, those are inherently considered unqualified. So if you said that the peas were processed in the U.S., that would be equivalent to saying that they were grown in the U.S. and packaged in the U.S. The use of one of those general terms, for example, processed in the U.S., with a qualification, such as the one I've got on the slides, and I apologize, they aren't. No, I am up there. Processed in the U.S. From U.S. and foreign ingredients is likely going to be interpreted, and this is not entirely clear from the guidelines because the guidelines do not focus explicitly, and particularly in their examples, on food products, but talk more about non-food products. In the context of food products, that sort of a qualified claim is likely going to be interpreted by the FTC as meaning that the last processing of the product has to have occurred in the U.S. and that the product was substantially transformed in the U.S. So if all that you do in selling your bag of peas is buy them from Mexico and then put them in a package in the U.S., you could not even use a qualified claim there because there was no substantial transformation under the test that Tim has already given you. So with those introductory topics, I'm going to turn it back to Tim to tell us something about what the penalties are for violation of these standards and who's responsible for those. Tim? Tim, have we lost you?
Oh, there we go. As we see the rules for determining the origin of imported food and food ingredients and the rules regarding the marking of those products can really be pretty complicated. But I guess foremost in everybody's mind is basically, so what? You know, how am I responsible? Who is responsible for the compliance with these marking requirements? And the basic position taken by the U.S. government, by Customs and Border Protection and other agencies, is that anyone who handles and processes imported goods in the downstream supply chain is responsible for ensuring that the origin of food and food ingredients is properly presented as information to the consumer so that he or she can make an informed purchasing decision. That means that the entire supply chain is potentially liable in the event that one step in that supply chain is engaged in any kind of funny business that might involve transshipment of product, mismarking, and mislabeling. And we're talking about potential criminal liability here, provided that the particular participant in the supply chain had knowledge of what was going on and either abetted it or failed to take steps to stop it. And that gets us into issues that surround questions of civil and criminal liability under the applicable laws and regulations. And before Lisa gives you a little more detail on that, three key elements in my mind are that the concept of knowledge in the mind of a U.S. prosecutor is very, very broad indeed. Not only what you knew, it's what you should have known. You can't outsource your responsibility for compliant operation. You can't contract it away to a customs broker or to a supplier, as important as contracts might be. And you can't ignore obvious signs of something funny going on. You can't ostrich yourself. And Lisa's going to speak at greater depth and walk you through this, really a nightmare landscape of potential liabilities if you don't tend to your knitting and make sure that your operation is running in a compliant fashion. Lisa?
Thank you, Tim. And I always love being introduced as somebody who is going to give you guys nightmares, so I apologize for that in advance. But I'm actually going to skip ahead to this slide, which gives you a little bit of an overview of what I'm going to be talking about. And while it may or may not be a nightmare, I feel very comfortable saying that we're living in an era of heightened scrutiny and increased regulations. And from personal experience on both sides of the fence, I can say that it is very, very difficult to negotiate a non-prosecution agreement or a deferred prosecution agreement on behalf of a company. It is so much easier for DOJ working with the FBI, CBP, and other agencies to just indict when they have the evidence. It's a lot more difficult to convince them that a company had a robust compliance program, that the compliance program was meaningful, that there was management buy-in, and that any errors were oversight and not some deliberate act or deliberate indifference on behalf of the target. Also, it's very easy to indict individuals, people who signed certifications, people who are on record as being the importer, people who email back and forth about a discussion about whether to buy a particular overseas product. And within that supply chain, there's always a lot of finger pointing. Nobody wants to be the ultimate person who's responsible, and unfortunately, in the government's view, pretty much everybody is, with always with the fallback of a conspiracy count. As long as there's an agreement can be an agreement to purchase goods, that agreement plus one overt act is sufficient to establish a conspiracy. Lastly, adding to the nightmare is the fact that there is increased funding for Customs and Border Patrol to address import issues and investigations, especially with respect to China. And so if you are importing products from China, especially where there's a robust anti-dumping duty in place, you've got to be extra vigilant. So a couple of enforcement issues we're going to talk about today. There are different levels of civil enforcement and also of criminal enforcement. And that's where I'm going to go backwards to talk about civil for just a minute. Customs and Border Patrol can impose additional duties in addition to what you have already paid in the importation of the product. This is often called a marking penalty, and it's up to 10% of the entered value of any of the goods not properly marked. So for example, if you say, look, we made a mistake and we meant to mark that as apple juice concentrate instead of apple juice, if the government agrees with you, they can say, okay, fine, you didn't have any bad intention there, but that is a civil penalty because you mismarked the product, and we're going to assess an additional duty on top of the duty that you've already paid. They also can seize and forfeit any mislabeled or adulterated goods, and that is basically strict liability. They seize first and ask questions later. There's a bulletin. It's called the MIT guidelines. It's actually a couple of hundred pages of guidelines that Customs and Border Patrol puts out, and that allows you to fight to get your items back, but they take first and ask questions later. CBP can also impose penalties under the Tariff Act up to $100,000 per occurrence for a willful failure to produce certifications regarding repackaging of imported goods. So this is a higher level of knowledge, still not rising to the level of criminal penalties, but imposing a substantial financial burden where that's at issue. CBP also can assert penalties under the Customs Fraud Statute. In Section 1592 and its counterpart, Section 1595, are actually very, very broad. If you have a mere clerical error, so again, to use my apple juice example, if you fail to label something as concentrate and just import as regular apple juice, that could be negligence, it could be oversight, it could be somebody thinking they don't have enough room on the customs importation form, but there is a penalty associated with that mere negligence. And it's the lesser of the value of the merchandise at issue, assuming that there's two different values associated with apple juice and apple juice concentrate, or 2 times the amount of duty lost plus interest. There's also a gross negligence standard and we've set that forth there. If there is fraud involved and Customs and Border Patrol decides to take mercy on you and not engage in a criminal investigation, they can still assess penalties of up to 100% of the domestic value of the entered goods, which is, as you may anticipate, very significant. With respect to other issues, I've mentioned forfeiture. I'm going to talk about criminal liability. One more that I want to add to this slide that frankly we just thought about right before the call started is the potential for additional private civil suits. Rich is going to discuss a little bit about how to get around some of that exposure through contracting in a couple of minutes, but we've seen this happen very recently where companies will negotiate a resolution with the government, non-prosecution agreement, deferred prosecution agreement, or even get indicted, and then others pile on with a series of civil suits to follow. And so you're really not out of the woods if you resolve either your civil or your criminal issue. You should think of them as parallel to each other. With respect to other potential criminal penalties, really low-hanging fruit is a violation of 18 U.S.C. Section 1001, which is false statements. It is a crime to make a false statement to the government. That includes making a false statement on any Customs and Border Patrol form. So this includes also false marking certificates, Forms 7501, Forms 3461, any other import documents. The penalty is a criminal fine of up to $10,000 and up to 5 years in prison per violation. This is an example of a certification from the CBP Form 3461. And you'll see on there that by signing this, you're certifying that the above information is accurate. It's unlikely that the government would bring a criminal case, in my opinion, based just on a false certification alone, but it certainly raises a red flag for the government and causes them to act or to investigate further. I will also say that this is going to be Exhibit A in any 1001 case because it helps prove knowledge. The person who signed this form is taking an affirmative step to say that they knew that things were as they seemed. Additional popular statutes that are being used to charge import violations are Section 545, which is the smuggling statute, Section 1341, which is mail fraud, and Section 1343, which is wire fraud. The panoply of customs violations is at 18 U.S.C. Section 541 to 555. Smuggling is one that the government relies on quite often because it includes the introduction of adulterated goods or mislabeled goods. And as Tim was talking about earlier, that's a bit of a landmine in and of itself. Adulteration can be simple. So you've got, for example, a pollen or a sugar that's not supposed to be in the food product. You've got an antibiotic such as tetracycline that is heavily regulated. Lead is another one that the government pays a lot of attention to. If you go over the allowed parts per billion, that is an adulterated product, and you can be prosecuted for importing that product under 18 U.S.C. 545 if you knew that you were doing so. With respect to mail and wire fraud, that's basically lying or making a misstatement to get something that doesn't belong to you. So if you pay for a product that you knew was imported illegally, then that payment, usually made by a wire transfer, would be the grounds for wire fraud prosecution because that payment is in furtherance of the scheme to obtain the product illegally. With respect to knowledge, Tim touched on this a little bit, and I want to spend some more time on it. You can only be liable under the criminal enforcement structure if you knowingly engaged in prohibited conduct. So it's enough if you had knowledge of facts that made the specific import, export, or sale illegal. However, you do not need to have knowledge of the specific law that you are violating. So for example, if you know that you're making a false statement or signing a false certification, you don't have to know that that's a specific violation of 18 U.S.C. 1001. You just have to know that it's not true. Importantly, individuals and corporations may not circumvent liability by ignoring warning signs and red flags, and we'll talk a little bit about red flags in a few minutes. And I'm sure you all know this, but companies are liable for acts of their officers, directors, and executives. So, for example, if a board of directors fails to have adequate oversight over the executives, or if the executives bury their head in the sand, then the company can be criminally liable just as the individuals can be. And more, the Department of Justice is issuing guidance memos saying that these prosecutions should be done in tandem. So the latest guidance is that where there is corporate criminal liability and a number of actors for whom the corporation is being held responsible, that DOJ should consider pursuing not just the company but also the specific actors with at least misdemeanor convictions. This slide is word for word out of the Seventh Circuit Federal Jury Instruction for knowledge. And this is what Tim was referring to earlier when he said that you can't ostrich. So I'm going to make one slight correction. Knowledge in the criminal law is not that you knew or should have known. It's that you knew or ignored the truth. And the biggest, this is really the biggest arsenal in DOJ's armory. If you suspect that something is not what it seems, and you say, I don't want to know about that, or I'm going to hold my compliance officer responsible for that, or that's for the board of directors to decide, and you do no further investigation, then you have the same amount of knowledge as the person who has personal knowledge of that criminal activity. And this is something that is being used more and more and more. It is this pattern jury instruction appears in every other circuit in some form or another. It is very well established law, and it is supported by the Supreme Court. In light of these penalties, one way to ameliorate your issues is to incorporate some contract protections into your relationships with suppliers. And for that, I'm going to turn this back over to Rich for a discussion of that.
Thanks, Lisa. As we've already made very clear, you can get into a significant amount of trouble in this area based on something that one of your suppliers may do. And of course, in that context, it's a very attractive approach and something that you really should be doing in dealing with suppliers to make them liable for their conduct to you for what you may suffer as a result of their misconduct, misrepresentations, and so forth. So agreements do have a role to serve here. They're not going to be a panacea that's going to solve all your problems if you get into one of these situations, but they can be useful and they can provide some level of recovery back against your suppliers if you use them properly. So for example, if a supplier makes a specific representation about the origin of a product, suppliers should be contractually agreeing or making that representation in writing, and should be contractually agreeing to cover your losses if it turns out that that statement is not true. And certainly if you want your attorney's fees to be covered in connection with those sorts of misrepresentations, you're going to have an indemnification clause in the agreement that they're signing, because without an indemnification clause that covers attorney's fees, you're not going to get to recover those. The other major point to make in this subject area is very often a client will come and say, okay, I see I have this supplier that's I'm relying on their representations in making certain representations about my own product, and this is in the marking and labeling area as well as any other sorts of representations that you may be getting from your suppliers that could get you into trouble. And the client will say, draft up a standard clause that I can put in my purchase terms, the fine print that go on the back of my purchase order, or that are included in my internet purchasing procedure, that are put in front of my supplier, so that he knows he's responsible for those things. Those kinds of fine print provisions have a place. Fine print is useful in some circumstances. And in the U.S., the Uniform Commercial Code slants things substantially in favor of buyers with what are called gap filler provisions of the Uniform Commercial Code that make a supplier generally liable for broad warranties on its products and for all losses that a customer incurs as a result of breaches of those warranties. So for buyers, fine print can be very valuable in at least disclaiming any attempt by the supplier to avoid that sort of liability. But fine print is not enough in this area because there is no implied warranty in the Uniform Commercial Code about what the origin of a product is. And so unless you have a specific agreement that specifies what the origin is supposed to be and specifies that the supplier that you're dealing with is going to be responsible for problems that result from the inaccuracy of that representation, you really don't have much. And as already noted, unless you have a clause that specifically covers attorney's fees, you are not, under U.S. law, going to be able to recover attorney's fees just as a general element of your damages for a misrepresentation. There has to be a specific agreement to cover attorney's fees. And in these situations, particularly on the civil side, the most serious losses often are the attorney's fees that you incur in trying to correct the problem or recalling a product and complying with all the laws that are relevant to that. Many purchasers, because of the difficulty of getting suppliers to sign their full set of fine print, will use one-page indemnification agreements to cover these sorts of problems. Those indemnification agreements will usually cover issues like the origin of the product, whether the product is adulterated or misbranded, and often also cover issues like product liability insurance, and certainly cover the attorney's fees that are incurred in connection with breaches of those representations. And I'm going to turn it back to Lisa now to talk about some of the red flags that she's already kind of teased us on.
All right. I'm not going to go through every single one of these, but to Rich's point, it's not sufficient to just rely on a consumer contract if you believe that there's some additional evidence that demonstrates that the contracting paperwork is inaccurate. I've listed a couple of slides of red flags that should tell anyone in a supply chain that there are compliance problems, and I'm not going to go through every single one of them, but I want to highlight a few. Price, again, is low-hanging fruit for the government. People who are purchasing and importing goods from foreign suppliers are often looking at the supply chain, and they know which countries actually have the capability of supplying a particular product and at what price. So especially when you've got anti-dumping duties at, say, 200 or 300% of the value of the product, if you are getting an offer for a product from a country that is lower than the anti-dumping duty, obviously that's a red flag. And even if the supplier says this is a one-time offer, or what they frequently do is they say, I've had these goods on the water or in a warehouse in the United States for X number of months, and I really, really need to get rid of them. One-time offer usually is too good to be true, particularly from a spot buy situation where you don't have an ongoing relationship with that contract partner. Another huge red flag is where there is insufficient, inconsistent, or imprecise product labeling. So for example, on your Form 3461, if your consignee name does not match the address, or if your container number doesn't match the country of origin, Or if you believe that you are buying peas and instead your product is described as carrots, and you don't do anything about it because you've got a course of dealing with somebody or you've got an email that says really you're buying peas, you're still going to be in a lot of hot water for accepting the goods with that imprecise paperwork. Another aspect of this I want to focus on in this list of red flags is something that's just facially invalid. So if you get a certificate of origin from one of your suppliers that says, I certify that I'm supplying product from Vietnam, and you know that there is no crop in Vietnam for that product, then your certificate of origin is false. And even if you have a suspicion, the internet is a wonderful tool, and at that point you really should be using it to ensure that the material that you're buying is from the country that it claims to be from. And so you really want to watch out for a lot of those red flags, because that is a suspicion and a combination of indifference to the truth and therefore criminal liability. So how do you fix this? I'm going to cover a couple of ways to fix it, and then I'm going to hand it back to Tim. You really need to manage your supply chain integrity. And when I was at the U.S. Attorney's Office, one thing that we did in every criminal investigation where we had executives, officers, directors, or people speaking on behalf of the highest levels of the company, they would always come in and they'd show me a copy of their compliance program. And on paper, the compliance program looks great. It requires the company to obtain meaningful paperwork. It requires the paperwork to be accurate. It requires people to actually go out and do audits of their suppliers. But then when you start asking questions of the executives and officers and people responsible, usually the only person who has any idea what's in that compliance program is the compliance officer. And then you'd actually be surprised at how few people in compliance really do own their own policies. And that's where the government gets you, because if you've got something that looks great on the shelf, but you're not actually implementing it, you're not actually using it, you're not actually training, then you might as well have nothing at all. So if you say in your compliance program that you're going to do something, you need to actually do it. And in the next couple of slides, I've got a list of things that the government looks for that you should do. Again, it's very easy stuff. You just have to actually do it. So if you obtain a copy of CBP paperwork, make sure that it's accurate. If you need to ask questions based on specific concerns in the source materials region. So again, if you know that there's no honey in Vietnam, you shouldn't be buying honey from Vietnam, and you should be asking where they're getting it from. Be careful of spot markets. Make meaningful supplier visits, meaning that if you're actually going to conduct an audit, that you have an audit tool that can make sure that you're asking the right questions and getting true and accurate information. The bottom line is that if you ask for the information, you want to make sure you get it. And if anything on the information does not look accurate or it looks like it's been tampered with, then you want to reject it. CBP does a traveling roadshow for some categories of imports, and they say over and over again that if you're accepting something that looks, where the paperwork looks like it's been whited out or there's markings or it's a cut and paste job, then they're going to hold you responsible as the purchaser for the inaccuracies in that information. There's also databases that you can subscribe to, for example, Datamine, to confirm that the product is imported in an actual container and it did come from the place that it says it's going to come from. And CBP is recommending more often than not that you subscribe to those. And now I'm going to hand it back over to Tim Sheehan to round out the compliance discussion.
As Lisa mentioned, it's important to have a compliance program in place that documents the efforts you're going to make to ensure that you're meeting all of your marking obligations and along with your other compliance obligations as a food or beverage company. And Lisa walked you through some of it. Let's talk for a quick second about record keeping, at least from a customs standpoint. Customs regulations regarding record keeping applies to importers of record, consignees, and others who caused the importation of goods. Now, if you buy imported goods from a U.S. supplier, you probably don't have an obligation under the customs regulations with respect to record keeping. It's not specifically imposed on someone who, I mean, if you didn't design the specification for the imported product, or you didn't take delivery of the goods DDP from a foreign source or a foreign country, or if you didn't otherwise, quote unquote, cause the importation to be made, you don't have a specific record-keeping obligation on the customs regulations. But having said that, in order to comply with your record-keeping requirements, you saw earlier that it entails the ability to certify to the government and certify to buyers that goods are properly marked to show country of origin. And if you're not marking your processed or packaged, U.S. processed or packaged food product with a foreign country of origin, you need to be able to document and prove that your product, the imported ingredients, underwent a sufficient substantial transformation. That means, as Lisa will confirm, that means you need to have records to prove it. It's an unfortunate truth, but just saying it's so doesn't make it so in the eyes of the government. And so if you're going to try and build a record to prove that you're marking your products in a compliant way, make sure you gather the information. Use your contracts to get the certifications from your suppliers. Keep those records. Keep a record of what you do with the stuff you buy. Best defense is a good offense. What does it take to have a properly robust compliance program? It needs to be appropriately designed to address the identified risks, in this case, country of origin marking, and it needs to meet the federal sentencing guidelines, which will mitigate your problems if there is a violation inadvertently. And that means top-level support. Tone at the top is so important. Effective communication of the compliance program and a compliance ethic throughout the company. You need to have programs that are designed to detect whether there's a marking problem, as Lisa mentioned. You need to have required contract terms, as Rich discussed. Training. The people that are in the trenches dealing with suppliers or dealing with the manufacturing process need to know what the rules are. Train them. You need to provide for an annual audit to make sure that your operations comply with the requirements of the compliance program. You need to give your employees an opportunity to report on a confidential basis any concerns they have regarding violations. And if there is an inadvertent violation, you need to be prepared to go in and confess. Confession is good for the soul. Disclose your violations, and you'll minimize the fallout. Now, questions. Let me announce the CLE code for our New York and New Jersey participants. That's M as in Mike, 5, I as in India, I as in India. That's M5II. So we'll take any questions. We don't see any on the online Q&A box, but there must be some. I know for sure I wasn't as clear as I should have been.
Tim, we have one question that came in.
Oh, good. What is it?
It's to make an unqualified claim made in the USA, virtually all raw materials must be of U.S. origin in the sense that they are grown in the U.S. or just significantly transformed in the U.S.
Is that a question? I mean, I would say the former part of that statement is correct. The latter is not. That is, substantial transformation in the U.S. means that there is significant foreign content in the product. So you can't make an unqualified claim. You could make a qualified claim, such as the percentage of content, approximate percentage of content, or some particular process was performed in the U.S., or even made in the U.S. if the actual final processing of the product is in the U.S. From foreign and domestic ingredients. But you could not make an unqualified claim merely because substantial transformation occurred in the U.S. In fact, again, substantial transformation in the U.S. implies that there was domestic or foreign content in the product. I hope I've addressed that.
Any other questions? Well, our hour is up, and I appreciate everybody taking the time to attend our webinar today. Please stay alert for notice of the next in the ongoing series of NewsFeed webinars. And if you should have any further questions or would like clarification of anything you heard today, please feel free to contact Lisa or Rich or me. We're in the book, or we're on the internet anyway. And thanks everybody for your attention.
And that does conclude today's conference. We do thank